You're tuned in to Agriculture Today, and we start our Wednesday show talking about a blog article from K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Well, good to be with you again, Shelby.
Roger, this blog article titled Resolving Land Disputes with the U.S. Forest Service, and what is this case that really brought this blog article to light?
Well, this is a pretty interesting case. It's a really tough situation that's been going on for the past couple of years under the Biden administration. There are some ranchers that have been ranching. They're fifth-generation farmers and ranchers in this area in South Dakota, east of the Black Hills and west of the Badlands. So if you're familiar with that area up there, there is some farm ground in between the Badlands and Forest Service land, which Custer State Park would be part of that. And, of course, the Badlands, that's where Mount Rushmore is at. So we're in that southwest corner of South Dakota. And this is Charles and Heather Maud. Charles's family had started farming in that area in 1910. And there was a line between private land and the Forest Service land. And then in the 1940s, I think it was, maybe early 50s, it's been about 70 to 80 years ago, the Forest Service put a fence in to mark the line officially. So there was a fence placed between the Maud's land and the Forest Service land. And that was done in accordance with the Forest Service survey that was done at the time. And it matched up to where the generations of the Mauds had been farming. So they just put a fence down that line. Well, the Forest Service had it resurveyed using new technology in recent years, and that showed that the Mauds were over onto Forest Service land to the tune of about 50 acres. And so didn't work this out with the Mauds. They filed criminal theft charges against Charles and Heather individually, each seeking that would have carried a 10-year prison term for each of Charles and Heather. Now, these are not these are young farmers. They have young children, and this was devastating to them. The government confiscated all their weapons and did put a gag order on them. They couldn't even talk to each other about the case. And so it was pretty gruesome for the family to go through this.
Where are we at now with the case?
Well, we had a change in administration, and the whole case finally came all the way to the White House. It got to the attention of President Trump, and there was a meeting primarily put together by Congressman Hageman out of Wyoming, Harriet Hageman. They got the Secretary of Agriculture together, Undersecretary of the Interior, as well as the Ag Secretary, along with Harriet Hageman. They had a meeting in the White House a couple of weeks ago and brought it to the President's attention, and he directed the Secretary of Agriculture to drop the case, drop all the criminal charges. So where we're at now is back to where we were before the criminal case was filed, and they're going to try to attempt to work out some resolution to this problem.
What does this mean for other properties potentially butting up to a U.S. Forest Service land?
Well, there are a lot of private landowners, particularly in the western part of the United States, that have this issue. They own land that's adjacent to Forest Service land, and they would run the risk of the same thing happening to them, perhaps. And so this sends a pretty good message that the current administration, at least, is going to uphold private property rights and try to work out solutions with farmers and ranchers in similar predicaments rather than just simply launching into criminal cases alleging that they had stolen government property.
And this isn't a case where that fence law matters.
No, and I've had lots of people ask me that. They say, well, we've got this concept of adverse possession or boundary by acquiescence. They'd been farming in accordance with a fence line, assuming that that was the property line, and that would be a boundary by acquiescence, or kind of the same thing as the opposite side of the same coin as adverse possession. Well, the problem is you can't use those theories against the federal government. Those apply to private property owners, and you can't assert adverse possession against the federal government. We've had a case like that in Kansas where it was tried to be asserted against the state government, and the court said you can't assert it against the state. So that then meant that Congress needed to do something about this, and Congress amended an existing law in the 2018 Farm Bill, which is the Farm Bill we're unfortunately still operating under, to expand the opportunity of the Ag Secretary to work out these types of boundary disputes with private landowners, and that's known as the Small Tracts Act.
And what are some points within that Small Tracts Act for what the Secretary of Agriculture can do?
Well, there are various sections of the Small Tracts Act. I think the one that's most directly relevant to the criteria for conveying small parcels and road rights-of-way to private landowners, which is what this bill allows the government to do, is that, well, there's a solution here. Let's just convey those areas in question to the private landowners that they've been farming anyway. And parcels up to 40 acres or less now, there used to be 10 acres or less. It's now 40 acres as amended by the 2018 Farm Bill. That are mixed in with or are next to lands that were transferred out of federal ownership under mining laws. That's one. Those parcels have to be determined by the Secretary to be inefficient to manage due to their location or size. Directly applicable to the situation in here, where you didn't have a mining situation that occurred, was if you've made improvements on the land in question, such as you put an irrigation well down so that you could run a pivot, which the mods do perform irrigation agriculture there. And so you've got improvements on that land. And you weren't given any advance notice that your improvements would be encroaching. So you had no idea that you were over the line onto Forest Service line. It was an innocent encroachment. Then the Act comes into play, and the Secretary of Agriculture, at the Secretary's discretion, can use that act to negotiate a deal where that you can end up being the title owner of that land in controversy. You can end up essentially buying that land at a value that the government determines.
What about for road right-of-ways when it comes to the Small Tracts Act?
Well, those can apply too. So if you have road rights-of-way, whether they're reserved or acquired, that are mostly surrounded by land that's not owned by the U.S., so it's not Forest Service land, and are no longer needed by the U.S. government. So in those cases, the owners of the land next to the right-of-way have the first opportunity to buy it.
And when we're thinking about land possibly switching hands, there's the SISC Act, and what is that?
Well, the SISC Act is basically a fund that is used to facilitate these transactions. And so it's a SISC Act fund is what it's called. And that's where the money is coming from to help facilitate these transactions, pay for the transactions, hold the money from the transactions, work out deals with landowners. There's a separate dedicated fund that Congress created to help the Secretary of Agriculture deal with these situations.
What would they do with that money they could potentially make from selling that land?
Well, the funds are to be used by the Ag Secretary for not only acquiring interests or land for recreational access. It's a mechanism for the Forest Service to adjust land ownership patterns within the National Forest Service through exchanges with private landowners, with the goal of making more efficient the management of the Forest Service land and making sure that we don't have checkerboard pieces of private land surrounded by Forest Service land where you would end up with more border issues. So it's to give an opportunity for the Forest Service to use this money to have contiguous tracts rather than pieces that are interspersed with private property where you could end up in these types of situations.
And you mentioned an irrigation well being on properties, but what if someone's accidentally built part of a barn on U.S. Forest Service property?
Yeah, that would count in the same category as an improvement. And those things happen, too. I'm sure we've got other landowners across the West where there's been some type of a structure, such as a barn or storage facility that's been put up that could be across a line someplace. Well, the Small Tracts Act is designed to deal with those situations. But again, whether that act is used or not is completely within the discretion of the Secretary of Agriculture. I think currently the mood with the current administration and the Secretary of Agriculture is to now resolve these issues and use the Small Tracts Act as intended by Congress. But prior administration and subsequent administrations may have a different view of these things.
What does this all mean for U.S. farmers and ranchers, Roger?
Well, I think one thing it means from a political standpoint is right now, if you've got this potential issue, you want to get it cleared up now during the current administration, because who knows what the future is going to hold. But what it means is you've got a way to resolve a boundary dispute that you may not have known about that actually was expanded in the 2018 Farm Bill, which we are currently using. And so there's that mechanism that's out there. It's a potential tool, but again, it's at the Ag Secretary's discretion to use this tool to minimize these disputes with private landowners.
If people want to find out more information about this or think they might have an issue with it, what's your recommendation?
Well, they can read the full article on my blog, and that's accessible through my website, which is washburnlaw.org. washburn.edu/WALTR, as well as on Ag Manager at K-State.
Roger, I appreciate you taking the time to join us today.
Thanks again, Shelby.
That was K-State and Washburn law professor Roger McEowen discussing his recent blog article titled Resolving Land Disputes with the U.S. Forest Service. If you would like to read this article, I will link it in today's show notes on agtoday.net. You can also find this article and other articles by going to agmanager.info or by going to washburnlaw.edu/WALTR. Again, those addresses are agmanager.info and washburnlaw.edu/WALTR.